Lawyers have read it. What's the most ridiculous argument you've heard in court? Story 1. The scratch-off lottery defense. Former prosecutor here, and I've heard some creative defenses in my time, but this one still makes me laugh years later. Picture this, arraignment court. The kind where we process dozens of cases in a morning, mostly routine stuff. DUIs, petty thefts, the occasional bar fight. Standard Tuesday morning fare. The defendant gets called up. Middle-aged guy, looks like he's been through this before. The judge starts reading the charges. You're charged with felony theft for stealing a roll of scratch-off lottery tickets from a gas station. The value of the tickets exceeds $300, which makes this a felony rather than a misdemeanor. Do you understand the charges? Now, most defendants at this point either plead not guilty and ask for a lawyer, or start making excuses about why they did it. Addiction, desperation, mental health issues, the usual sad stories that led them to steal. Not this guy. This criminal mastermind had clearly spent his time in lockup crafting the perfect defense. He straightens up, looks the judge dead in the eye, and delivers his argument with the confidence of Johnny Cochran. But, Your Honor, to be fair, the tickets were all losers. The courtroom goes silent. The court reporter's fingers hover over the keys. The bailiff tries not to laugh. Even other defendants waiting their turn look confused. The judge, bless his patience, takes a moment before responding. I'm sorry, what? The tickets, Your Honor. I scratched them all. They were losers. Every single one. So technically, they're worthless. How can I steal something that has no value? I'm watching this unfold from the prosecutor's table, and I'm genuinely impressed by the audacity. The man had stolen an entire roll of scratch-offs, probably 100+ tickets, taken them home, scratched every single one, discovered they were all losers, and thought, aha, my defense. The judge, maintaining his composure like a true professional, Sir, the value of lottery tickets is determined at the point of sale, not after they've been scratched. But they're worthless now. That's not how it works. If you steal a television and it breaks when you get home, you still stole a television. But I didn't know they were losers when I took them. Exactly. Wait, no, I mean, his public defender is frantically trying to get his attention, making the universal "please stop talking" gestures. But our hero is committed to his defense. Your Honor, it's like stealing a wallet that turns out to be empty. No harm, no foul, right? Wrong. You still stole a wallet. But, sir, let me explain this differently. When you buy a lottery ticket, you're purchasing the chance to win. The gas station paid for those tickets at full value. They expected to sell them at full value. The fact that none of them happened to be winners doesn't retroactively make them free. The defendant's shoulders slump as reality sets in. His brilliant defense, the one he'd probably excitedly explained to his cellmates, the one that was going to get him off scot-free, crumbles before his eyes. So, even though they're losers, still theft. All of them? Every single ticket was a loser? Still theft. The beautiful part? He'd essentially confessed to the crime, while trying to argue his innocence. Yes, I took the tickets. Yes, I scratched them all. But they were losers, so it doesn't count. His lawyer finally gets a word in. Your Honor, we'd like to plead not guilty and request a continuance to discuss this matter with my client. Translation, I need to explain to this man why his defense is terrible before he talks himself into additional charges. The judge sets a trial date. As they're leading the defendant away, he's still muttering about the injustice of being charged for stealing worthless tickets. The kicker? If he hadn't scratched them, they'd still have their full retail value. The gas station could have returned them to the Lottery Commission for credit. But scratched tickets? Actually worthless. He'd destroyed evidence that could have potentially reduced his restitution amount. I saw him again at what was supposed to be his trial. His lawyer had clearly walked him through reality, because he ended up taking a plea deal. But I will never forget watching the air go out of him as he realized that his foolproof defense, the one where he thought he'd outsmarted the entire legal system, was basically just a detailed confession with extra steps. The lottery tickets were losers, but honestly, so was his defense. Though I have to admit, in all my years as a prosecutor, I'd never seen someone so confidently argue that they'd committed a more thorough version of the crime they were accused of. Usually, defendants try to minimize their actions. This guy maximized them and thought it would help. His logic was essentially, "Your Honor, I didn't just steal them, I stole them and destroyed their value. Checkmate." To which the legal system basically replied, "That's worse. You do realize that's worse, right?" As the bailiffs moved in, the defendant looked genuinely confused. He turned to his barrister and said, "But you said I would get bail." The barrister, still in shock, replied, "That was before you told the judge you were a flight risk. But I was being honest. That's the problem." The Leeds Crown Court disaster. I was a law student in the early 90s, observing a case at the Leeds Crown Court. I was sitting in the public gallery with my notebook, trying my best to look professional and not like the clueless student I actually was. The case was heavy. A 75-year-old man, known as a pillar of his community, was accused of a very serious offense against his 13-year-old relative. It was the kind of case that makes you reconsider a career in criminal law. His barrister was good, really good. He made a compelling plea for bail based on the defendant's standing in the community. Established businessman, family man, no prior record, strong local ties, not a flight risk, etc. The usual pillar of society defense that sometimes works. The judge seemed receptive. It really looked like bail was going to be granted. Then the judge, following procedure, turned to the defendant. "Sir, do you have anything to say before I rule on bail?" Now, any lawyer worth their fee would have prepped their client for this moment. The correct answer is either a simple "No, Your Honor," or something bland about having faith in the justice system. That's it. This man, however, stood up, adjusted his suit jacket, and delivered two statements that will forever be burned into my memory. Statement number 1. He tried to justify his actions. He stood up and made an appalling comment attempting to shift the blame onto the young girl by referencing what she was wearing. The temperature in the courtroom dropped about 20 degrees. The barrister's face went from confidence to absolute horror in real time. The prosecutor didn't even try to hide their smile. You could hear people in the gallery gasp. The judge, maintaining remarkable composure, said, "Sir, this is a preliminary hearing, not a trial. You should wait until the trial to argue your case, especially with statements that are far from helpful to your situation." But our defendant wasn't done. Oh no, he had a second barrel to fire. Statement number 2. "I cannot reappear in a month because I am flying back to my home country tomorrow and will not be coming back." The barrister actually put his head in his hands, like full-on face-in-hands despair. This poor lawyer had just spent 20 minutes arguing his client wasn't a flight risk, only to have the client himself announce his literal flight plans. The judge's face cycled through shades of purple and white as he processed what he'd just heard. Did this man just confess and announce he's fleeing the country? "I'm sorry," the judge said, his voice dangerously calm. "Did you just say you're leaving the country tomorrow?" "Yes, Your Honor, I have business to attend to." "And you are not planning to return?" "No, Your Honor. Why would I?" The prosecutor didn't need to stand up. He didn't need to say a word.
The defendant had just made the single greatest argument against bail in British legal history. The judge's ruling was swift. Passport seized, defendant remanded in custody until trial, next case. As the bailiffs moved in, the defendant looked genuinely confused. He turned to his barrister and said, "But you said I would get bail." The barrister, still in shock, replied, "That was before you told the judge you were a flight risk. But I was being honest. That's the problem."
What made it worse, or better, depending on your perspective, was that this wasn't some poor, uneducated man who didn't understand the system. This was, allegedly, a successful businessman, a pillar of the community. He'd been in the country for decades. He should have known better. But apparently, when given the opportunity to speak, he decided to 1. Essentially admit guilt, 2. Blame a 13-year-old's clothing choices, 3. Announce his escape plan. It was like watching someone play Russian roulette with a fully loaded gun. The other law students and I compared notes afterward. We'd all written the same thing: never let your clients speak without preparation. One of my classmates summed it up perfectly. His barrister spent 20 minutes building a house of cards, and the client took a flamethrower to it in 30 seconds. I later heard from a clerk that the barrister had to be talked out of withdrawing from the case immediately. Can't blame him. Imagine prepping for weeks, crafting the perfect bail argument, only to have your client stand up and essentially say, "I did it because she was dressed provocatively, and, by the way, I'm fleeing the country tomorrow. Thanks for the help." The case became legendary among Leeds law students. Professors would reference it. Remember, no matter how good your argument, your client can destroy everything if they open their mouth, like that fellow in Leeds who announced his flight plans. To this day, I wonder what was going through his mind. Did he think honesty would be rewarded? Did he believe the judge would understand about the very, very tight shorts? Did he assume announcing travel plans was just being courteous? The moral of the story: sometimes the worst enemy of a defendant isn't the evidence, the prosecutor, or the judge. It's the defendant's own mouth. And somewhere in Leeds, there's a barrister who still wakes up in cold sweats, hearing his client say, "I'm flying back to my home country tomorrow and will not be coming back." Story 3. The Buttery Smooth Jacket Defense. Law student here, sharing my professor's favorite courtroom disaster story. He told it every semester without fail, usually right after teaching us about Fourth Amendment searches. The case: defendant busted for drug possession. Police found narcotics in his leather jacket pocket during a pat-down. Pretty standard drug case, happens every day in criminal court. But this defendant thought he'd found the perfect loophole. His argument was actually clever, in a too clever for your own good way. During a legal pat-down, officers can only seize items if they can identify them as contraband through plain feel, meaning they have to be able to tell it's drugs or weapons just by touching the outside of the clothing. So our genius defendant argues, "Your Honor, my jacket is buttery smooth leather, the finest leather money can buy. Feel this leather, it's like silk. There's no way the officer could have felt the drugs through this magnificently smooth leather. Therefore, the search was illegal." His theory: if the leather was too smooth and thick for the officer to identify the drugs by touch, then the officer had no legal reason to reach into the pocket. Illegal search, evidence thrown out, case dismissed. The judge, intrigued by this novel argument: "Counselor, is that the jacket in question that your client is wearing?" Defense attorney, seeing where this is going but unable to stop it: "Yes, Your Honor." Judge: "I'd like to examine this allegedly impenetrable leather jacket. Would the defendant please approach and hand the jacket to the bailiff?" The defendant, proud of his buttery smooth jacket and convinced he's about to beat the system, struts up to the bench, takes off his jacket with a flourish, hands it over like he's presenting evidence that will exonerate him.
The bailiff takes the jacket, starts to hand it to the judge, then stops. "Your Honor, there's something in the pocket." The judge, trying not to smile, "What's in the pocket, bailiff?" The bailiff reaches in and pulls out a bag of white powder. The courtroom goes dead silent. The defendant's face goes from smug to shocked. The defense attorney looks like he wants to crawl under the table. "Judge, let the record reflect that the defendant brought narcotics into my courtroom. Bailiff, please arrest the defendant for possession of a controlled substance in a judicial building." Defendant, but it's my jacket. You can't search it." Judge, "You handed it to me voluntarily for examination. That's consent." Defense attorney, defeated, "Your Honor, I'd like to request a recess to discuss a plea arrangement with my client." So not only did the defendant fail to get the original evidence thrown out, he committed a new crime by bringing drugs into the courthouse, provided fresh evidence against himself, and proved that his buttery smooth leather wasn't too thick to feel drugs through, because if the bailiff could immediately tell something was in the pocket, so could the arresting officer. My professor would always end the story with, "This is why you never bring the evidence to court. Describe it, show pictures, submit expert testimony about leather thickness if you must, but for the love of all that is holy, do not bring your drug-filled jacket to court to prove it's too smooth to feel drugs through." The best part? The defendant's original argument wasn't even legally sound. The plain feel doctrine doesn't require officers to identify exactly what the object is, just that it feels like contraband. A bag of powder feels like a bag of powder, regardless of leather quality. But even if his argument had merit, he destroyed it by wearing the evidence to court, voluntarily handing it over, having drugs in it while in court. The case went from "maybe we can suppress this evidence" to "the defendant brought drugs to court in front of a judge." My professor kept a photo of the police report on his office wall. Circled in red was the line, "Defendant arrested for possession of controlled substance in judicial building after voluntarily surrendering jacket containing narcotics to demonstrate leather quality." Every time a student would suggest bringing physical evidence to court, he'd just point to that photo. But what if? I really think. In this case, the moral of the story: when your defense is "the jacket is too smooth to feel drugs through," maybe, just maybe, make sure the jacket doesn't currently have drugs in it. Or better yet, leave the jacket at home and stick to legal arguments that don't require show and tell. Somewhere out there is a man who went to court to prove his jacket was too smooth to feel drugs through and ended up proving it wasn't smooth enough to hide the drugs he brought to court. That's not buttery smooth. That's just butter-brained. Story 4. The Prius Logic Defense. Traffic court, where hope goes to die and logic takes a vacation. But sometimes, just sometimes, you witness something so spectacularly stupid it makes your whole day. I'm there fighting my own speeding ticket. 78 in a 65, Highway Patrol got me fair and square. The courtroom is packed with the usual suspects: people who weren't speeding, people who had to pee, and people who think crying will help. Then she gets called up. Mid-40s, dressed like she raided Ann Taylor's clearance rack, carrying a folder that looked suspiciously like it contained evidence. She had that look. You know the one? The "I've figured out the system" look. The "wait until the judge hears this" energy. Judge, "Ma'am, you're charged with going 73 in a 55 zone. How do you plead?" Her, "Not guilty, Your Honor, and I can prove it with logic." The judge actually perked up. After hearing I wasn't speeding 47 times that morning, someone promising logic was at least interesting. Judge, all right, I'll hear your logical argument. She opened her folder with the confidence of someone about to present the cure for cancer, pulled out a printed photo, held it up like Exhibit A in the trial of the century. Her, Your Honor, I drive a Prius. She paused for effect. The courtroom was silent. The judge waited for more. There wasn't more. Judge, and? Her, That's my proof. Judge, Ma'am, I'm going to need you to connect some dots here. Her, sighing like the judge was a particularly slow child. I drive a Prius. Judge, you've established that. How does that prove you weren't speeding? And then she delivered the argument that would echo through traffic court history. Driving a Prius proves I'm responsible, specifically in the realm of cars. Responsible people don't speed. Therefore, I couldn't have been speeding. It's simple logic. The judge stared at her. The bailiff stared at her. Everyone stared at her. You could hear the fluorescent lights buzzing. Judge, let me understand your argument. You believe that owning a hybrid vehicle is evidence that you don't break traffic laws? Her, not just owning, choosing to drive a Prius. It shows environmental consciousness, which correlates with rule-following behavior. I have studies. She had studies. In her folder, actual printed studies about hybrid owners' personality traits. Judge, Ma'am, the officer clocked you at 73 miles per hour. Her, the radar gun must have been wrong. Check the logic. Would someone who cares about maximum fuel efficiency drive 73 miles per hour? No, it's inefficient. I get best mileage at 55. Judge, so you're saying you always drive 55? To maximize efficiency, yes. Judge, then why didn't you just say you weren't speeding? Because that's just a claim. This is logic. Prius equals responsible equals not speeding. It's syllogistic reasoning. She actually said syllogistic reasoning in traffic court about a speeding ticket. The judge rubbed his temples. Ma'am, plenty of Prius drivers speed. Her, those aren't real Prius drivers. They're just people who happen to own Priuses. Priuses, Prii, whatever. Real Prius drivers understand the responsibility. At this point, I'm convinced this is performance art. No one can be this confidently wrong. Judge, your argument is that the type of car you drive determines whether you follow traffic laws. Exactly. You understand. It's like how people with rescue dogs are more empathetic, or how people who shop at Whole Foods are healthier. People who shop at Whole Foods still get diabetes, ma'am. Not real Whole Foods shoppers. The prosecutor didn't even object. Why would you? She was hanging herself with organic, sustainably sourced rope. Judge, I'm going to stop you there. The radar showed 73. The officer testified you were going 73. Your defense is that Prius owners don't speed because they're responsible? Her, it's logic. It's not. Guilty. The fine is $180. This is discrimination against logical thinkers. No, it's a fine for going 18 over the speed limit. Next case. As she gathered her folder of studies, she muttered loud enough for everyone to hear. A Hummer driver would have gotten away with it. I saw her in the parking lot afterward, getting into her Prius. She peeled out of the space and cut someone off exiting the lot. Responsibly, I'm sure. The best part? I told this story at a party weeks later, and someone said, "Oh my God, I know her. She tried to get out of a parking ticket by arguing that Prius drivers don't park illegally." Apparently, she had a whole system of Prius-based legal defenses. Prius drivers don't speed, disproven. Prius drivers don't park illegally, also disproven. Prius drivers don't run red lights, probably disproven. Prius drivers don't commit tax fraud, status unknown. The moral of the story: your car doesn't make you responsible, your actions do. And claiming that driving a specific brand of car makes you incapable of breaking laws isn't logic. It's the kind of argument that makes judges question their career choices. Somewhere out there, she's still driving her Prius, still convinced that her vehicle choice is a legal force field, still getting tickets, and still confused why her logic doesn't work. But hey, at least she's getting great gas mileage while she speeds.
Story 5. The Jesus paid my debt defense. I've seen some creative defenses in my time, but this pro se litigant took it to a whole new spiritual level. Setting: civil court. Case: credit card company versus defendant who owed about $7,000. Pretty straightforward collection case. She'd had the card, used the card, stopped paying the card. Usually these end with either a payment plan or a judgment for the creditor. But this lady had found what she believed was the ultimate loophole. Not in law books, in the good book. She showed up dressed like she was going to church, because in her mind, she kind of was. Had a well-worn Bible, highlighted and bookmarked with colored tabs. Legal pad full of notes. The confidence of someone who discovered something everyone else had missed. Credit card lawyer presents the case. Here's the card agreement, here are the charges, here are the missed payments. She owes $7,000. Judge: Ma'am, do you dispute owing this money? Her: Your Honor, I'm so glad you asked. I don't owe this money anymore. Judge: Did you pay it? Better than that, it's been paid by the highest authority. The credit card lawyer looked confused. The judge looked intrigued. I was observing from the gallery and immediately pulled out my notepad because this was going to be good. Her: Your Honor, may I present my evidence? She opens her Bible with the reverence of someone handling nuclear codes. Her: Romans 13:8 says, "Owe no man anything." Clearly, God doesn't want us to have debt. Judge: Ma'am, that's about... Furthermore, Proverbs 22:7 says, "The borrower is slave to the lender." God doesn't want me to be a slave. Credit card lawyer: Your Honor, I don't think biblical verses override contract law. I'm not finished. She flipped to another tab with the precision of a biblical scholar. Her: Here's the important part. Matthew 6:12 says, "Forgive us our debts as we forgive our debtors." God forgives our debts. Judge: That's about... But wait, there's more. Colossians 2:14 says, "Christ canceled the record of debt that stood against us. He set it aside, nailing it to the cross." She looked around triumphantly. Your Honor, Jesus Christ died for our sins. Debt is a sin. Therefore, Jesus died to pay my Visa bill. It's already been paid in full at Calvary. The courtroom was dead silent. The credit card lawyer's mouth was hanging open. The court reporter looked up from her machine like, "Am I really typing this?" Judge: Ma'am, are you seriously arguing that Jesus' death 2,000 years ago paid your credit card debt? Not arguing, proclaiming. It's right there in Scripture. He died for all our sins, financial sins included. Credit card lawyer: Your Honor, this is... Sir, do you believe Jesus died for our sins? Lawyer: That's not relevant to... Do you or don't you? Judge: Ma'am, please don't interrogate opposing counsel about his religious beliefs. Her: I'm establishing that debt forgiveness is a recognized religious principle. Jubilee years, debt cancellation. It's all biblical.
She pulled out printouts of various prosperity gospel websites, highlighted passages about God wanting his children to be debt-free, testimonials from people who prayed their debt away. Your Honor, if a Muslim can refuse to pay interest because of religious beliefs, why can't a Christian refuse to pay debt that Jesus already paid? Muslims don't refuse to pay debts, they might avoid interest-bearing. You know what, never mind. Ma'am, while I respect your religious beliefs, Jesus did not co-sign your credit card. He doesn't need to co-sign. He's the Alpha and Omega. His credit is perfect.
At this point, I'm trying not to laugh. The bailiff is biting his lip. Even the credit card lawyer looks like he's fighting a smile. Judge, let me make sure I understand. You charged $7,000 on this credit card? Yes. Judge, you received goods and services for that money? Yes. And you believe you don't have to pay because Jesus paid it? Exactly. You understand. I understand your argument. I don't accept it. The debt is valid. Judgment for the plaintiff. This is religious persecution. No, it's contract law. You can't charge earthly goods and claim heavenly payment. But, ma'am, when you get to heaven, you can take it up with the accounting department. But here on earth, in this courtroom, you owe Visa $7,000. As she gathered her biblical evidence, she muttered, "Render unto Caesar what is Caesar's, but this debt belongs to Jesus." The credit card lawyer, as we're all leaving, "In 20 years of collections, that's a new one." Another lawyer, "Think it would work for my student loans?" Everyone, "No." But somewhere out there, she's probably still telling people about how the court system persecuted her for her faith and refused to acknowledge Jesus's unlimited credit line. And honestly, points for creativity. Using the crucifixion as a debt consolidation plan takes serious theological audacity. Jesus died for your sins. Amen. Including financial sins. Well, including Visa. That's not how it works. Religious persecution! Story 6. The Dog Saliva Yeast DUI Defense. I wasn't a lawyer, just juror number 7 in what became the most memorable DUI trial in courthouse history. The kind of case that gets passed down through generations of court staff like folklore. The facts were straightforward. Defendant ran a red light directly in front of a cop, crossed 3 lanes of traffic without signaling, blew 0.19, more than twice the legal limit. Open and shut case, right? Wrong, because this defendant had a scientific defense. Her lawyer stands up for opening statements, and I swear he looked like he was dying inside before he even started speaking. Ladies and gentlemen of the jury, my client was not intoxicated. She was the victim of a rare biological phenomenon involving her dog, a cut on her arm, and yeast. The prosecutor's face? Question mark. The judge's face? Question mark. My face? Question mark. The defense attorney continued, reading from what looked like notes written in crayon. My client had a small cut on her arm. Her dog, Mr. Whiskers— "Mr. Pickles," the defendant shouted. "Sorry, Mr. Pickles," licked the wound. The yeast from the dog's saliva entered her bloodstream through the cut and began converting her blood sugar into alcohol. I looked at my fellow jurors. Everyone was frozen in various states of disbelief. The attorney continued. This internal fermentation process, similar to how beer is made, created alcohol inside her body. She wasn't drinking, she was fermenting. The prosecutor stood up. "Objection, Your Honor, that's not how biology works." Defense, "We have expert testimony." Oh God, they had an expert.
The expert turned out to be a guy who ran a home brewing supply store. Not a doctor, not a biologist. A guy who sells yeast to people making bathtub beer. Expert? Yeast converts sugar to alcohol. That's science. Prosecutor? In a human body? Well, theoretically. Prosecutor? Have you ever heard of this happening? I've heard of autobrewery syndrome. Prosecutor, is that what the defendant has? No, that's different. This would be dog-based brewery syndrome. Even the defense attorney looked embarrassed. But wait, it gets better. The defendant insisted on testifying. Defendant, I never drink and drive, never. Ask anyone. Prosecutor, ma'am, you were seen leaving Chili's. I only had water. Prosecutor, the receipt shows 3 margaritas. Those were virgin margaritas. Prosecutor, virgin margaritas are just juice. Exactly, juice that my body turned into alcohol because of Mr. Pickle's yeast. She then went into extensive detail about Mr. Pickle's licking habits, how he was a chronic licker, how she had cuts all over from her active lifestyle. She showed us old scratches that looked suspiciously like they were from picking at scabs, how Mr. Pickles had particularly yeasty saliva because he ate a lot of bread. Prosecutor, you feed your dog bread? He loves sourdough. At this point, I'm writing notes to look busy, but I'm really writing, what is happening? The prosecutor's closing argument was basically, please don't make me explain why dog spit doesn't turn you into a human brewery. She drank 3 margaritas. The end. The defense's closing? Science doesn't lie. Yeast is real. Dogs lick people. Therefore, reasonable doubt? We deliberated for exactly 12 minutes. 10 of those minutes were us making sure we all heard the same thing. 1 minute was voting, 1 minute was walking back. Guilty. As we're leaving, I heard the defense attorney talking to the prosecutor. I told her to just plead no contest. I begged her. But no, she read about autobrewery syndrome online and thought, I can work with this. The best part? During sentencing, she tried to bring letters of character from her neighbors. One mentioned what a responsible pet owner she was and how Mr. Pickles was always clean and well-groomed. See, she shouted, clean dog, no excess yeast. The judge, ma'am, that makes your defense worse, not better. She got 6 months license suspension, fines, and mandatory AA meetings. At least she didn't blame the AA requirement on Mr. Pickles. Though I wouldn't have been surprised if she'd argued that she couldn't attend because she might get licked by service dogs and ferment again. To this day, whenever I see someone letting their dog lick them, I think, careful, you might become a brewery. And somewhere out there, Mr. Pickles is still licking people, blissfully unaware that he was blamed for a DUI in what might be the stupidest defense in legal history. Virgin margaritas plus dog yeast equals drunk driving? That's not science. That's not even science fiction. That's just fiction with a really confused dog. Story 7. The $6,000 Mattress Saga. Workers' comp attorney here. I've seen people milk injuries for everything from massage chairs to hot tubs. But this lady went to war over a mattress. Her claim, upper back injury and, of course, complex regional pain syndrome, CRPS. For non-lawyers, CRPS is like the jackpot of workers' comp claims. It's hard to disprove and can justify almost any treatment. One day, she decides her regular mattress is making her condition worse. Does she ask for a basic orthopedic mattress? Maybe a nice Tempur-Pedic? No. She demands a $6,000 therapeutic sleep system with memory foam that remembers your dreams or something, heating elements, massage functions, Bluetooth speakers for healing vibrations, presumably, NASA technology because astronauts have back pain too? Some kind of copper infusion. What? And not a twin or queen, a California king, because her unemployed boyfriend also needed therapeutic sleep apparently. For months, we litigated this damn mattress. Her attorney filed motion after motion, medical documentation about optimal spine alignment, sleep studies, expert testimony from a chiropractor who probably got his degree from a YouTube video. My client offers $500 for a decent mattress. Not good enough. We go up to $1,000. Nope. $1,500 final offer. Her attorney acts like we offered food stamps. The judge starts every hearing with, "Are we seriously here about the mattress again?" Finally, the judge pulls us into chambers. "I swear to God, if either of you says the word mattress in my courtroom again, I will hold you both in contempt. I have murder trials. I have custody battles. I have real cases. You've wasted 6 months of this court's time on a fucking mattress. Figure it out." We settle. She buys the $6,000 mattress herself. My client reimburses her $1,500 just to end this nightmare. Everyone leaves unhappy, but done. 3 months later, we're back in court. She's seeking a variance for additional chiropractic care beyond what's allowed by law. "Judge, why do you need more chiropractic treatment? I thought the mattress was supposed to help." Her lawyer starts explaining about muscle tension and spinal adjustment and blah, blah, blah. The judge turns to her. "Ma'am, why do you think you need more treatment?" She pauses, looks at her lawyer, looks at the judge, and then delivers the line that will echo through courthouse history. "Well, Your Honor, I'm having a lot of trouble sleeping on my mattress." The silence was deafening. You could actually hear the court reporter's fingers freeze over her keys. The judge's face went through the 5 stages of grief in real time. Denial. Did she just... Anger. Visible eye twitch. Bargaining. Looks at ceiling as if asking God why. Depression. Shoulder slump. Acceptance. Dead-eyed stare. Her own attorney tried to salvage it. What my client means is... "No," the judge interrupted. "I want to hear from her. Ma'am, are you telling me that the $6,000 mattress you made us litigate for months is causing you sleep problems?" Her, "Well, it's too firm." Judge, "Too firm?" Her, "The memory foam remembers too much." Judge, "It remembers too much?" Her, "And the massage function vibrates my spine wrong." I'm trying not to laugh. My co-counsel is biting his pen. The bailiff has turned away to face the wall. Judge, "Let me make sure I understand. You spent 6 months of this court's time demanding a specific $6,000 mattress. You testified it was medically necessary. You had experts testify it was crucial for your recovery. You bought it, and now you're telling me it's making things worse." Her, "The Bluetooth speakers give me headaches." Judge, "Then don't use the Bluetooth speakers." Her, "But I paid for them." The judge looked like he was about to have a stroke. The vein in his forehead was doing things veins shouldn't do. Judge, "Motion denied. Case dismissed. And if I see any of you in my courtroom again about anything related to sleep, mattresses, beds, pillows, or any bedroom furniture..."
Story 8. The Self-Suing Slip and Fall. Personal injury attorney here. I've had people try to sue God, act of God defense taken literally, sue their own children, attractive nuisance doctrine gone wild, and once had a guy who wanted to sue himself for emotional distress. He lost an argument with his reflection. But this sweet old lady took the cake. She hobbles into my office on a walker, probably 80 years old, looking like everyone's grandmother. Floral dress, sensible shoes, purse full of hard candies. "I need to sue for my injuries," she says, easing into the chair. "Of course, ma'am. Tell me what happened." "Well, it was February. Terrible ice storm. I was going to get my mail, and I slipped on the driveway. Broke my hip. Terrible fall. I was in the hospital for weeks." I'm taking notes, already thinking about premises liability. "I'm so sorry to hear that. Where did this happen?" "My driveway." "Your driveway? You mean the driveway of the property you were visiting?" "No, dear, my driveway, at my house." I put my pen down. "Ma'am, who exactly are you wanting to sue?" "Well, the property owner, of course. They didn't salt the driveway. No sand, no ice melt, nothing. Completely negligent." "Ma'am, you're the property owner." "Exactly." She said it with such confidence that for a moment I wondered if I was the one missing something. "Ma'am, you want to sue yourself?" "Well, yes, I was negligent. I should have salted that driveway. I knew there was ice. I've lived in Minnesota for 60 years. I know better." "But you can't sue yourself." "Why not? If someone else had fallen on my driveway, they could sue me, right?" "Well, yes, but so why can't I sue me? I'm a victim of my own negligence." She pulled out a folder. She had prepared for this. Photos of the icy driveway, medical bills, a written timeline of her failure to salt. She'd built a solid negligence case against herself. "Look," she said, showing me receipts. "I bought ice melt in November. Never used it. It's still in my garage. That's negligence." "Ma'am, even if you could sue yourself, which you can't, your insurance—" "Exactly. My homeowner's insurance. They should pay for my medical bills." And there it was, the light bulb moment. She thought she'd found a loophole to make her homeowner's insurance pay for her medical bills. "Ma'am, that's insurance fraud." "How is it fraud? I really fell. I really was negligent. I have the evidence right here." "Ma'am, you can't create a liability claim against yourself to trigger your own insurance coverage." "But if the neighbor kid had fallen, that's different. That's a third party." "I don't see the difference. A victim is a victim." She was getting agitated, waving her medical bills around. "Look at these bills, $40,000, all because I didn't throw some salt on the driveway. Someone should pay." "Ma'am, that's what health insurance is for." "I have Medicare. They don't cover everything, but my homeowner's insurance would." I spent the next 20 minutes explaining why she couldn't sue herself. She kept coming up with counterarguments. "What if I incorporate? Can I sue my corporation?" "No." "What if I transfer the house to my daughter and then sue her?" "That's still fraud." "What if I go back in time and salt the driveway?" "That's not possible." Finally, she gathered up her carefully organized evidence of her own negligence, shaking her head. "This country's legal system is broken," she muttered. "Can't even hold myself accountable for my own actions." As she's leaving, she turns back. "What if I slip again? Can I sue myself then?" "No." "What if I slip on purpose?" Definitely no. The legal system is so complicated, she sighed, hobbling out. 2 weeks later, I got a call from another attorney in town. "Hey, did you have an old lady come in wanting to sue herself for a slip and fall?" "Yes." "She just left my office, brought a whole presentation, photos and everything." "Please tell me you didn't take the case." "Of course not, but she did ask me something new, if she could sue her past self for not buying long-term care insurance." Apparently, she made the rounds to every personal injury attorney in town. Each one has their own story.
She asked one if she could sue herself for emotional distress for causing her own physical distress. She asked another if she could file a class action on behalf of all elderly people who don't salt their driveways. She asked a third if she could sue the weather for being icy, then sue herself for not suing the weather sooner. Last I heard, she'd moved on to trying to get the city to cite her for not maintaining her property, hoping that would trigger some kind of insurance claim. She never did get anyone to take her case. But somewhere in Minnesota, there's an 80-year-old woman with the most meticulously salted driveway in America, just in case she finds a lawyer willing to help her sue herself. And honestly, her case against herself was better documented than most legitimate cases I see. If you could sue yourself, she'd have won. But you can't. No matter how much evidence you have of your own negligence, no matter how creative your legal theories, you cannot sue yourself. Though God knows she tried.